Trade associations can file amicus briefs in any case in which they think that their insight would be valuable to the court.
The Weekly Friedman, your source for the most essential information in the default industry, with your host, Adam Friedman.
We're back with another FAPA update. Our firm has recently filed an amicus brief on behalf of the American Legal and Financial Network with the New York Court of Appeals, and I'm joined today with Senior Appellate Counsel Stephen Vargas, who actually drafted the amicus brief. Steve, how's it going?
Great. How are you, Adam? And good to talk about another advocacy effort by the firm.
How many amicus briefs can you file? Are these different? Why is one with the United States Supreme Court? Why is one with the New York Court of Appeals? What's going on here?
They are different. And one thing I want to mention to lead with is that firm partners Mike DeRosa and Zach Gold, once again, were involved with the amicus brief, just like with the Supreme Court brief that we talked about in a prior weekly Friedman filed in U.S. Bank v. Fox. The trade associations can file amicus briefs in any case in which they think that their insight would be valuable to the court. The purpose of an amicus brief is in large part to give the court some perspective beyond what the parties provide the court in their briefs. So previously, the firm represented 5 trade associations, national and state, in the amicus brief in the U.S. Supreme Court. Here, the firm represents a 6th trade association, the ALFN, in connection with the brief filed in the Court of Appeals. One difference, actually, between this process and the process in the U.S. Supreme Court was that technically there's a motion required for leave to appear as an amicus curiae in the Court of Appeals, and in the U.S. Supreme Court, a motion's not required. The interested party, the trade association, can just file a brief and explain in the brief why they're interested in the case and why their insight would be valuable. Here, not only did we have to prepare and file a brief, we had to prepare a motion explaining in more detail, actually, than the Supreme Court even requires, why the trade association's insight would provide valuable perspective to the court when adjudicating the appeal. And in the case we filed the brief in is Article 13 LLC versus Ponce de Leon Bank, which originated in the Federal Trial Court, Eastern District, New York, and ultimately went to the Second Circuit Court of Appeals, and then came over to the Court of Appeals in New York based on certified questions issued by the Federal Appellate Court.
So let's say our amicus brief is successful in both courts. Are we getting the same thing out of both?
Not immediately. So that's an interesting point too. In Fox, the Supreme Court case, the amicus brief is asking the Supreme Court to take the case. Just hear the case on the merits. Hear U.S. Bank's arguments as well as Fox's arguments, even though we're advocating against Fox's position, hear the arguments of each party on the merits and ultimately issue a decision. So it's a 2-step process in the Supreme Court. In the event that Supreme Court takes the case and actually will hear the appeal on the merits, we may feel compelled, or the trade associations may feel compelled to file the brief again or update its brief. In the New York case, there will be a final opinion issued by the New York Court of Appeals on certain issues regarding FAPA. Now, interestingly, the issues presented, even though we talk about FAPA broadly, the statute with all its different amendments, there's actually different issues that are being reviewed by the Court of Appeals in connection with the appeal we filed the brief with respect to, and the Supreme Court. The U.S. Supreme Court is looking at whether a certain FAPA amendment, CPLR 205-A, the Savings Statute Amendment, violated the due process and or takings clauses of the federal Constitution. The New York State Court of Appeals is not tasked with answering the question as to whether any FAPA amendment in Article 13, at least, the case where we filed the brief, they're not tasked with actually answering any questions about the U.S. Constitution. They're tasked with answering 2 questions. The first is whether or to what extent any FAPA amendment applies to foreclosure actions commenced before FAPA's December 30th, 2022 effective date, and if it's retroactive, whether the retroactivity violates the due process clause of the state constitution. So the briefs, and that's why it was important to get the perspective of the amicus out there, not only to the Supreme Court, but to the Court of Appeals, because it's different issues. In the Supreme Court, there's no issue presented as to whether FAPA itself is retroactive. There's, for purposes of the constitutional arguments, based on New York precedent, it's retroactive. However, the Court of Appeals briefing gives us an opportunity to address why the statutory text is not even sufficient to indicate the legislature's preference for statutory retroactivity. So it was really important to have the trade association client's voice heard here.
Okay, so with the U.S. Supreme Court, what we're hoping for long term is that the U.S. Supreme Court answers whether or not FAPA's retroactivity violates the due process clause of the U.S. Constitution.
As well as the takings clause, correct. That's the scope of what our brief discusses, and to my recollection, that's the scope of what U.S. Bank is arguing in the case, that it violates both of those clauses.
And then with this new amicus brief filing, we're asking the New York Court of Appeals to decide, one, whether this statute should be applied retroactively, and if that's answered affirmatively, whether or not that violates the New York State Constitution.
Absolutely. And it's solely the takings clause of the New York State Constitution. And the reason I'm framing the two issues, and you framed them as well, the reason they're being framed in the manner in which they're being framed is because the issues were essentially identified by the federal appellate court when they certified the questions. They certified those two specific questions, whether or to what extent the statutory text is sufficient to indicate retroactivity, and like you said, if retroactive, does it violate the due process clause? The certified questions are not broader than that. They don't discuss the federal constitution. They don't discuss any other potential clause that could be relevant in the state constitution. They do, however, allow the Court of Appeals to issue a more broad opinion. The circuit court allowed the Court of Appeals the opportunity to basically expand or modify these questions to the extent they see fit. And the reason I say that is because the actual scope of the certified question only concerns one FAPA amendment, which was the amendment at issue in the Article 13 case. I think what the circuit court is hoping for is that the Court of Appeals will take the opportunity to opine more broadly on FAPA as a whole. Maybe the retroactivity clause issue, as far as interpretation of whether it's retroactive at all, maybe that'll be a broad enough discussion. I don't know if the Court of Appeals would discuss the constitutionality of every single FAPA amendment because they are not at issue in this actual appeal. So we'll see. They gave them an opportunity to do that. The circuit court did. The Court of Appeals just accepted the questions. They didn't give any indication whether they'd expand on the questions or anything in their one line, questions accepted decision that they issued. So that is really something that very interested to monitor. Oral argument is going to be held on October 16th. The amicus does not get to argue in the case. However, the parties will argue, and I think that is when we're going to know, which is also, by the way, broadcast live. It's live streamed by the Court of Appeals. So it's a must-watch event for anyone who's interested. You can get in touch with us and we'll send you the link for it. That's, I think, when we're going to know what the scope of the analysis will be and whether we get a very broad, potentially definitive ruling on these two issues, or whether it's going to be a piecemeal analysis saying this particular statutory amendment is or is not constitutional, but leaving open the possibility of challenging one of the other statutes down the road. And kind of circling back to your initial question, how many amicus briefs can you file? In the event that the Court of Appeals decision is not comprehensive, there may be an opportunity down the road or a need down the road to file more amicus briefs if other FAPA amendments make their way up to the Court of Appeals for consideration.
If the New York Court of Appeals determines that FAPA should not be applied retroactively, does that then render our amicus brief at the U.S. Supreme Court moot?
It would, and I think that would be a best case scenario for the industry. The retroactivity clause is the most objectionable aspect of FAPA. Although there's certainly drastic ramifications to prospective application, you haven't seen challenges. It's much more difficult to challenge a statute being applied prospectively. The majority of the challenges that have been made would become irrelevant because the arguments about due process are much more narrow in the event that a statute's simply prospective, because you'd have actual notice and an opportunity to comply with it. But yes, the Supreme Court briefing is based on the presumption or based on the fact that the appellate courts in New York have applied the law retroactively. So in the event the Court of Appeals issues a final ruling opining on the retroactivity clause, saying it's actually not a retroactivity clause, or the way it's applied retroactively is to an action brought before it, but only to occurrences in the action that post-date the effective date. But I think to answer your question, bottom line would be, I think it would render the Supreme Court action moot.
We've now filed 2 amicus briefs in an effort to represent the industry on FAPA-related questions. Do you see this as the beginning of you and our firm filing more amicus briefs, or is it really just that FAPA was such a big deal?
Certainly, it's an exciting opportunity for the firm. It's a great opportunity for attorneys. And frankly, the trade associations have been very supportive of the idea too, because their name's going on this. I do not think this is the end. It shows the firm's capabilities as far as being able to handle the highest levels of litigation. As far as court is concerned, you don't get higher in New York than the Court of Appeals, nor do you get higher in the nation than the Supreme Court. From an attorney's perspective, it's really an exciting part of an attorney's career.
Yourself, Zach, and Mike are clearly the best, not just in the state, but in the entire country. It's great to have you on here. I appreciate it.
Absolutely. Thank you.
Thank you for joining Steve Vargas and I on the Weekly Friedman, your source for the most essential information in the default industry. Thanks for tuning in and looking forward to seeing you next time.